to everyone. Welcome to everyone. We appreciate your gathering with us this evening on a very important topic, United States immigration, understanding the current situation and how we can help. We're very glad to have Robert Cohen as our speaker tonight. And this webinar is being presented by the League of Women Voters of Metro Columbus, and particularly our Advocacy and Education Committee. And I'm going to put a plug in right at the beginning. We're always looking for new members to join us on that committee. Go ahead to the next slide. So in a minute, we'll have Dr. Jay Ramanathan introduce our speaker, Robert Cohen, and we'll save time at the end for our question and answer and discussion and next steps. But Robert will field some questions as we go, as long as they're on the specific aspect that he's talking about at that time. And then there'll be opportunities for more questions at the end. Next slide, please. We always want to start by telling you a little bit about the League of Women Voters of Metro Columbus. We are always 100% nonpartisan. So that means we never endorse parties or candidates. So that means you need to be nonpartisan in your questions and your discussion as well. And the best way to do that is think about the issue, not the person. Our mission on the League is to educate and engage voters and safeguard our democracy. And we do that by thoroughly and fully embracing diversity, equity, and inclusion. Go ahead to the next slide, please. A couple of ground rules during the presentation. We're going to mute all participants, so please put any questions that you have in the chat, and either Jay or Sophia or I will see those questions and we will ask Robert those as we go along. We want it to be very clear as we're going along and answer your questions on that aspect as we go along. All right, next slide, please. Now I'm going to turn it to you.
I would like to introduce Rob Cohen with a little incident that took place in 1985-86. We were reminiscing about a student of mine while I was a professor who got into a little bit of trouble on a student visa. And as a professor, we feel very protective of our students. This was an Indian student, and Rob Cohen went all out to help the student, and he eventually became a senior technical fellow at a major telecommunications company. So a little help goes a long way, and that is very illustrative of Rob Cohen, who's actually a very modest person. So I'm going to spell out a little bit of what he's done. 45 years of experience, and a lot of it is in all aspects of business and family immigration procedures. He has also served on several important boards, specifically Board of Trustees of the American Immigration Council, and he has also served as a board member of the Community Refugee and Immigration Services and the Columbus Jewish Historical Society. I also remember that he has actually successfully won a class action suit. So with that, I'll let Rob pick up on the actual presentation.
Thank you, Jay, for that introduction. I would like to start. Why don't we move to the next slide? With a little bit of background. This is very basic, but I find that people generally don't really understand a lot of the language and the distinctions we make in immigration law. So I want to distinguish between immigrants and non-immigrants. And immigrants are people who are here permanently. The vernacular is a green card. We use the term LPR, lawful permanent resident. And an immigrant has the right to live and work in the United States permanently. And at some point, and we'll talk about this, can become a citizen. Non-immigrants, on the other hand, are here for a temporary time period for a very specific purpose, and their status as a non-immigrant is governed by a series of complicated regulations that are particular to whatever that category is. And those categories go, they're designated usually by letters, A through U, I think. A through U. Each one has a separate set of regulations. Some of the common ones are visitors for business, visitors for pleasure, temporary workers, that's the H-1B. We'll talk a little bit about that. L-1s, O-1s, P-1s. They all have separate individual categories. We're not going to go through those, although if there's any specific questions, we can address that. Temporary protected status is a topic that we'll discuss also in some detail. What is not included here, but I understand that there might be some questions about what constitutes an undocumented immigrant. As I was thinking about this, I neglected to provide a slide. But let me talk for a minute about undocumented immigrants. In the popular press and on the street, you'll often hear the term illegal alien. It's not a term that I recognize or will use. An alien is defined by the Immigration Act as a non-citizen, and nobody is illegal as a person. People can't be illegal. There are violations of immigration law that puts you into different categories. You may have been here in a temporary status and overstayed. That would be a violation of your non-immigrant status. You can also violate the rules of a non-immigrant status. For example, if a visitor is working without authorization, is a category that is disfavored. It's not provide. I mean, it's a violation of immigration law. The other category of people that we see are those who have entered without inspection. We call them EWIs, entry without inspection. And each of those different categories has certain penalties and consequences of the violation. It's not the same. And there are, for some categories, there are provisions that can be overcome, and for other categories, there aren't. And it gets relatively complicated. Going back just real quickly, the path to LPR for immigrants is usually family-based, employment-based, or humanitarian. And each of those are a little bit different. They sort of speak for themselves in terms of the category, but they all have a set of rules that govern that particular category. Okay, let's move to the next slide. And one of the questions that I saw in advance and wanted to respond to is, how do you apply for citizenship, naturalization? How do you become a citizen? Well, you can't just apply for citizenship. You must be a permanent resident for 5 years. And you become eligible to apply. You can actually apply 3 months before the 5-year period, but you can't be naturalized until you've been a permanent resident for 5 years. That theoretically gives you time to learn about the United States and become assimilated and acculturated. Because of that requirement, it's reduced to 3 years if you are the spouse of a U.S. citizen. So you have to be married and living with a U.S. citizen for 3 years, and that reduces the 5 year to 3 years. The process involves an application, a civics and history test. The test was revised about 3 weeks ago. The current test for applications that are filed on or after October 20th, I can tell you we filed a couple of applications on October 17th to take advantage of the current test. It's a little bit harder. You'll be asked 20 questions instead of 10 questions, and you have to get at least 12 of them correct. The test questions are available in advance, and it's basic history and civics that I like to think that most of us who went through school in the United States could answer. Although they've done some studies, and Americans are not always able to pass the test. For those of us who were born here and are already citizens, we don't need to take that test. One of the requirements for naturalization is to demonstrate good moral character. Historically, this has been relatively simple. The question is, have you been convicted of any crimes? And in the absence of any criminal record, there's generally a finding of good moral character. The current guidance, however, is a little bit more rigid, and the Immigration Service has been authorized to do further study, including visits to your neighbors to see what your neighbors have to say about your moral character. There was a question that showed up on my screen and then disappeared. So I need to figure out, it's in the chat room, right? Are revisions to the civic test typical every few years, or is the latest revision an abnormal change? The previous test was, we call it the 2009 test, and that was in effect since 2008 or 2009. During the first Trump administration, the Immigration Service proposed a more difficult test that lasted until the last election, or to the 2020 election. It was jettisoned under the Biden administration, and under the Trump administration, we have a new, more difficult test once again. How long that will last, I don't know. The answer to your question is, we haven't seen, in the 45 or 48 years I've been doing this, there have not been a lot of revisions to the test. This is a little bit abnormal. Filing fees are listed. One way to become a citizen, other than the process that I've outlined as a permanent resident for either 5 or 3 years, is if you are in the military. Soldiers, sailors, anybody in the service is eligible to apply for naturalization, irrespective of their time period as a lawful permanent resident. There's even a military program called the MANV, which is military acquisitions for vital positions or something. I don't remember exactly what MANV stands for. But if you have particular skills that the military needs, you are eligible to enlist in the military under the MANV program, and can apply for citizenship right away, irrespective of your immigration status. So I have had a number of clients who were foreign students or in H-1, but had specific skills, enlisted in the military, and became a citizen without going through the whole permanent resident process. It's an exception, it's unusual, but it works for the military. Why don't we move to the next slide? One of the questions that, again, that I was trying to address was, why is immigration such a hot topic? What is the problem? And I tried to give some thought to that. And I think the basic answer is that we don't have a consensus across the political spectrum on the values that drive or respond to immigration. On the one hand, those of us who are advocates for immigrants and immigration, we go back to the inscription on the Statue of Liberty. Give me your tired, your poor, your huddled masses yearning to breathe free. And we like to think of America as a country that responds to crisis by accepting refugees and immigrants from around the world. We're also very much aware of the economic benefits of immigration. I was reading a study earlier today. Something like 46%, I may get the statistic wrong, but I think 46% of Fortune 500 companies were founded by immigrants or children of immigrants. And there's an economic drive to it. Jay referenced one of her students back in the 1980s. That's a success story. He's now a senior director for a major corporation. I like to think that most of my clients fit that category over the last 45 or 50 years. I can think of a lot of doctors. Many in the technology world. I've had a lot of clients who have worked for major employers for several years. They get their green card, they become citizens, they leave and they start businesses. It's a economic benefit. Immigration is clearly an economic benefit. There was a study done about 10 years ago. I'm on the board of CRIS, Community Refugee and Immigration Services, and they commissioned an economic study about 10 years ago on the economic benefits to Central Ohio for refugees. Now, refugees are generally, they come, they're poor, they don't have, some of them come with little more than the clothes on their back. But as a practical matter, they assimilate and very quickly and move into the workforce. The number of ethnic restaurants speaks to the number of immigrants who have become part of the economic engine. The problem of immigration is that immigrants are often targeted and scapegoated for problems. September 11th, I think, is the classic example. And we have been talking about comprehensive immigration reform, for 30 or 35 years. And I know that there was discussion on September 10th, 2001, of an immigration reform package. That discussion ended the next day. And quite frankly, there hasn't been a serious discussion since then. I think a lot of the scapegoating of immigrants misses the benefits. We're beginning to see how that works in the deportation efforts that are happening today. Businesses are struggling to find workers. as their staff are being cut out of work authorization or even deported. And so we're seeing some negative impact in the economic world of the harsh treatment of immigrants generally. And then there are those who think that that's an appropriate way to protect Americans. It's it's a debate that has continued, quite honestly, for generations. As I was thinking about this today in preparation, I remember seeing a book that was written in the 1950s by a academician at Johns Hopkins. His name was John Higham, I believe. And I don't remember the name of the book, but his theory was as society goes through changes, a lot of times xenophobia becomes the reaction to changes. And when we look back to at the history of immigration law, the early immigration restrictions were passed as we were entering the Industrial Revolution. Society was undergoing a change. And the reaction to that was a bit of xenophobia. Go back to the Chinese exclusion laws of the late 1880s. And this was the beginning of the Industrial Revolution. Exactly how things are changing today, I'll leave to the pundits, but artificial intelligence, when Al Gore invented the internet back in the 90s, that was a major change. And as we're adjusting to that, there is a backlash against immigration and immigrants. So let's talk about what some of those backlashes are. If we can go to the next slide. This is a list of current issues that are racking the immigration world. And they result from executive orders and proclamations from the president over the last 10 months. Let's start with birthright citizenship. And if we can go to the next slide, which addresses birthright citizenship. There was an executive order that was issued on January 20th that limited birthright citizenship. To be clear, birthright citizenship is provided in the 14th Amendment to the Constitution. This was passed in the aftermath of the Civil War, and it provides that all persons born in the United States and subject to the jurisdiction thereof, and that phrase is critical, are U.S. citizens. Historically, we've understood the only people who were not subject to the jurisdiction of the United States were accredited diplomats who had diplomatic immunity and enemy soldiers being held as prisoners of war. I'm not sure how often that has occurred. I do know that there were a number of prisoner of war camps during World War II in which Germans were held. Don't know. I don't have a whole lot of knowledge, historical knowledge about any other wars where there were enemy prisoners held. But enemy prisoners and diplomats are the only people historically who have not been subject to the jurisdiction of the United States. Those of us who, lawyers, would argue that if somebody is not subject to the jurisdiction of the United States, you can't charge them with a crime. And you've seen that if you watch Law and Order. A number of times they'll have a case where a crime is committed by somebody who has diplomatic immunity, and the police are unable to arrest them, and he or she cannot be prosecuted because of that immunity. But we don't have that immunity for anybody who would not qualify for citizenship under this executive order. It provides that anybody that has anybody born in the United States whose parents are not citizens or permanent residents are not U.S. citizens. This executive order has been held unconstitutional by virtually every court that has addressed it. And there are 3 or 4 courts that have addressed it. One of the issues early on, there was a case that held it was unconstitutional and issued a nationwide injunction against the application of the executive order to children born after the date of its effective date, which I think was February 17th or sometime around there. That issue went up to the court. They heard oral arguments on May 15th and issued an order that, quite frankly, shocked many of us and held that courts did not have the authority to issue a nationwide injunction. It did not consider the merits of whether or not the executive order was constitutional. The oral argument, particularly Justice Kagan, argued that we have to assume it's unconstitutional because it's blatantly unconstitutional. But given that question, can the court issue a nationwide injunction? By a vote of 6-3, the court held they cannot. The response to that was to convert one or two of those cases to class actions, and the class was certified. That has now moved up and is now before the court on the merits of the case, merits of the question of whether or not the executive order is constitutional. The court has not yet granted certiorari, which means that they haven't agreed to hear the case. I will be surprised if they don't. On the other hand, it would be a pretty slick move for the court to deny cert, and that would leave the courts of appeal decisions as the operable case law that controls. And I think 3 of the courts of appeals at this point have held it as unconstitutional. One of the issues. So let's move on. Another issue that I have been dealing with on a regular basis was the executive order also on January 20th, suspending all refugee resettlement programs. The United States, when I first started practicing immigration law in 1979, was my first case. Shortly after that was the 1980 Marilito boat lift from Cuba. Many of you may remember that. Those of you who are a little younger may know of it from the history books. But there were thousands, I believe, of individuals from Cuba that came on boats and landed in Florida, overwhelming the Florida coast in terms of refugee requests. As a result of that, the Refugee Act of 1980 was passed that provided for a more orderly processing of refugees abroad. Once they are determined to be refugees, the president can determine a number of refugees that would be admitted each year. The executive order on the on the 20th held that or terminated all refugee resettlement programs and also suspended funding for all existing programs. That was challenged in a case called Pacito versus Trump. It was filed in the Seattle Federal District Court. It has a relatively tortured history in the courts. It was Judge Chen, it was the district court judge, held that it was unlawful. The executive order was unlawful. But the fallout from exactly what that meant has been the subject of several court decisions that have gone up and down the courts, including the Supreme Court, that has left it a little bit uncertain. At this point, the program has been mostly on hold. The presidential determination of September 30th was issued for the next fiscal year. This was published actually on October 31st. And it sets a refugee ceiling of 7,500 refugees. Compare that to the last year of the Biden administration, where the number was 125,000. The difference, however, is that the determination that set it at 7,500 gives white Afrikaners special treatment. This has created an enormous discomfort in the refugee resettlement community because the refugee resettlement program takes years. I'm working with a client who from Somalia. It took her 13 years to achieve refugee status before she was able to come to the United States after having fleeing her home. I think she was 4 or 5 years old when her family left Somalia, and she wasn't given refugee status. It was a 13 or 14 year process. There are thousands of people in that pipeline, and they are all put on hold for the white Afrikaners, which has not been well received. I think it's putting it mildly to say it has not been well received in the refugee resettlement issue or refugee resettlement community. Let's move on to I'm not paying close attention. Help me out on time. We're good for a little while. Okay, is that right? Okay. Okay. So the next topic I'd like to talk about is the travel ban. During the first Trump administration, we called it the Muslim ban. Was issued first on January 27th, 2017, a week into the first administration. It created an enormous amount of chaos at the airports. And you may remember all of the scenes of people at airports and the demonstrations. It was held unconstitutional by a number of courts, and there were a series of attempts to revise the ban until ultimately it was found to be acceptable in Trump versus Hawaii, which was a Supreme Court case, I want to say 2018. The travel ban and much of the current administration's efforts to limit immigration are based upon Section 212F of the Immigration and Nationality Act. And that gives the president the authority to determine that certain immigrants or immigration categories are a security risk to the United States. And it is that section that the Supreme Court upheld in Trump versus Hawaii and is the basis of the current travel bans. On June 4th of this year, there were travel bans that were published by the administration. There was a full travel ban for 12 different countries that were identified as countries that did not properly vet or maintain criminal records and provide those to the United States as to vet visa applicants, and therefore any citizen of those 12 countries is banned from any admission to the United States. 7 additional countries were named for a partial ban. Those countries, citizens of those countries cannot be admitted in either visitor or student status. There are some exceptions to the travel ban. I've listed a few of them here. If somebody who is already a permanent resident is not covered. Dual nationals, if you have 2 passports, one of them's from a banned country and the other from a country that is not banned, they're excluded. We are hosting the World Cup and Olympics in the next couple of years. These travel bans wreak havoc on the international competition. Competitors have been accepted from the travel ban. That doesn't necessarily apply to fans. So if you are a fan from one of the banned countries and would like to come and see your team play in the World Cup, not going to happen. Spouses and children of U.S. citizens are accepted. There are special immigrant visas for Afghans who helped the United States during the war in Afghanistan. And refugees and asylees already admitted are also accepted from the travel ban. Okay. Let's move on to the next slide. And we'll talk about TPS. So TPS is a function of the 1990, the Immigration Act of 1990. We call it IMAC 90. And it was an effort to find a category that would provide some sort of humanitarian relief for people who were already in the United States when something catastrophic, that's my use of the term, the statute doesn't use the term catastrophic, something pretty serious happens in the home country that makes it unreasonable to ask people to return to that country. It can be political, it can be war, it can be climate, Central American hurricanes, and the devastation that many of the Central American countries experienced 20 years ago was the basis of granting TPS for citizens from some of those countries that, and what it does, it allows temporary protected status. It gives individuals who qualify based upon their physical presence in the country as of a certain date. It gives them the ability to obtain work authorization and remain in the country, usually in periods of 18 months. At the beginning of this administration, there were 17 countries that were designated for TPS. And they had various, some of them had been designated for a number of years, some of them more recently. But the Department of Homeland Security has sought to terminate TPS for large numbers of those individuals, most notably Haiti and Venezuela, as well as some of the humanitarian programs for Ukrainians have been probably most notable. What is truly remarkable about the termination of Haiti and Venezuela is when you look at the statute requires the continuation of TPS if conditions in the country remain dangerous and have not improved. And when you look at those two countries in particular, they're still, the problems have not been resolved. It is still very dangerous for people to return to either of those countries. Haiti in particular. The airlines no longer fly to Port-au-Prince because their scheduled airlines were being shot at as they landed at the airport. The gangs have completely taken over. The political situation in Venezuela is pretty desperate. And in fact, we see the administration arguing that military actions against Venezuelans, even to the point where we hear consideration of ground actions actually landing military in Venezuela as a means of addressing that issue. And yet TPS has been terminated. So these things have been challenged in the court in various court cases. TPS, National TPS Alliance versus NOAM, is one case in particular for both Haiti and Venezuela, and it has been up and down in the courts. The federal district court, as well as the circuit courts, have found that the termination was unlawful based upon the statutory language that I just described. And the Supreme Court, in a very brief decision, held that without addressing on the merits, they held that the injunction against enforcing the determination that you could not terminate TPS could not hold. You had to let the government is permitted to enforce the termination until the court's final ruling is made. The chaos that this has created is enormous. There was a Supreme Court in that decision in May had the decision was done on what's called the shadow docket, and it was 2 paragraphs. So there wasn't a whole lot of reasoning. Actually, that's overstating. There wasn't any reasoning. It just stated that the injunction was dismissed until the case was fully adjudicated. It did hold that any documents that were issued before the termination remained valid. And what that means is when TPS for Venezuela was extended on January 17th by the Biden administration, once that notice was published in the Federal Register, individuals were given a period of time, I think about 12 months, to apply for extension of their TPS status that expired at a later date. The termination of and the revocation of that finding was published on February 5th by the current administration. The Supreme Court held that any individual who applied for an extension of TPS between January 17th and February 4th remained eligible for continued work authorization based upon that pending application. Anybody who did not apply during that 2-week period lost their work authorization. And it's that kind of detail and crazy analysis that has left employers and hundreds of thousands of individuals trying to figure out whether they're work authorized or not. And in the meantime, those who are not, unless there is some other basis for them to stay, they're subject to deportation proceedings, which we call removal proceedings. Let's move to the next slide and talk about deportation for a little bit. I think it's an understatement to say that the government is engaged in very aggressive efforts to find and detain immigrants subject to removal. We're seeing widespread actions in cities. I don't need to tell you about this. It's in the news every single day about how ICE is seeking to arrest, detain, and remove immigrants. Lawyers are pushing back with habeas petitions to challenge detention. Often the courts are sympathetic to those petitions, but it's the best thing I can say about it is it's full employment for an awful lot of immigration lawyers, and it's a real cat and mouse game. Okay. I suspect that there may be some specific questions about that. Okay, let's go to the next slide. Problem that I have here is I have a copy. Okay, so let's talk about some of the high-profile issues in the deportation world. Mohammed Kahil is a lawful permanent resident. He was an outspoken student at Columbia University, opposed to many of Israel, the IDF, Israeli Defense Forces actions in Gaza. And as a result of that outspoken position, the Secretary of State, under Section 212F of the Act that we talked about before, found that his continued presence in the United States presented a security risk. As a result, he was arrested and actually deported to El Salvador. You know something? I'm mixing up cases. I don't think he was deported to El Salvador. He has been held and released. There are 2 or 3 cases about that. The issue that is ultimately going to be addressed is whether the Secretary of State has the authority to make a finding that a particular individual's continued presence in the United States is against our national interest. One of the really interesting cases, I like to talk about this case. That provision was only tested before Khalil's case, was only tested in the courts one time, and that was in 1998. And that decision was issued by a federal district court in New Jersey and found that the provision that the Secretary of State could find somebody's presence to be contrary to our interest was unconstitutional. The interesting part about that decision was the judge who issued it, Judge Mary Trump Berry, whom you may recognize as the current president's sister. The case went up to the Court of Appeals, and the Court of Appeals reversed the decision in a decision that was written by Judge Alito before he was Justice Alito. But it wasn't on the merits. It was based upon a question of standing. So before Khalil's case, there was really no other precedent other than Judge Berry's decision, 1998 decision, finding that unconstitutional. I suspect that there's going to be more adjudication on that issue. I don't know how that's going to play out. One of the things, okay, the really unfortunate, sad, and human story behind that particular case, Mexico was seeking to extradite the individual at issue in that case. And it was our relationship with Mexico
that the Secretary of State had determined needed to be protected by returning this individual to Mexico for prosecution. I don't know the details. I don't remember the exact details, except that I think the prosecution was considered by many to be a political prosecution. We never reached a final conclusion because the individual committed suicide before that happened. So that was the end of that story. Another basis of the deportation efforts is the Alien Enemies Act, which is an act that was first enacted by Congress in, I think, 1797, was used during the War of 1812 to seek the deportation of enemies, and again in World War I and World War II. Other than that, it had never been used. The current effort has named Venezuelan citizens alleged to be gang members to be alien enemies, and on that basis has removed a number of Venezuelans, a lot of high-profile cases sent to El Salvador and held in that prison. Supreme Court has approved the use of the Alien Enemies Act, but it did require individuals be given an opportunity to defend their claim that they are not members of the gang. Some of those people they're still in Venezuela. So that has created also a great deal of controversy and litigation. Okay, let's go to the next slide. We also saw the termination a few months ago of student visas, and there was again the same statute. Secretary of State determined that foreign students, large numbers of foreign students, their presence was contrary to our interest. They terminated SEVIS records. SEVIS records. So what are SEVIS records? This is inside information. SEVIS is the student and exchange visitor information system that tracks all students and exchange visitors. SEVIS was created after September 11th. You may remember Muhammad Atta, one of the September 11th terrorists, I think probably considered the ringleader, had a student visa. He attended flight school. And it was that gap that we didn't know anything about him that the Congress created as part of the Homeland Security Act, the database that we know as SEVIS. All foreign students are required to have a SEVIS record. And when that record was terminated, then students became deportable. It left students without status or work authorization. There was no notice to their employers. There was a flood of litigation. Almost every court, I think there were close to 100 cases that were filed within a week or two. And with two exceptions, all of the cases determined that the termination was unlawful. The government has abandoned those efforts to deport students. They were all reinstated, but there was a great deal of chaos in the meantime. The result of all of this has been a significant drop in the number of applicants for foreign student visas. And schools have noticed significant drop-off this academic year of foreign students, which there's all kinds of policy issues as to why I think that
is a bad policy. Bringing the best and brightest students from around the world to study in our schools has always been a real boon to our academic institutions, as well as those who stay and work. It's been an economic boon as well. They're going to go elsewhere. They got the message. Coming to the United States, there's no longer a welcome notice in the United States. There are those who applaud that because they think that that leaves more opportunities for U.S. students. I'm not sure that it's a zero-sum game. That's my own opinion, shared by a number of experts, however. Let's move to the next screen. I think we're getting close to the end. Here's a number of resources. Each of these links, all of these institutions have a lot of material that is useful. The top one, full disclosure, as Jay noted in her introduction of me, I'm a past chair of the board of the American Immigration Council. I think they do a lot of wonderful work. There is an enormous amount of policy discussion on their website. There's a lot of legal resources for lawyers, but there's also policy discussion for the lay community as well. And I think that also applies to the other other organizations listed. Okay, a word, just one word, and I know this because Jay indicated a question earlier this morning in an exchange of emails. One of the organizations, I think it's the Immigrant Legal Resource Center, has what's known as red cards. Which a red card is in several different languages and says, I have the right to a lawyer. I have the right to remain silent. I wish to exercise those rights. I don't want to answer any questions, and I would like to speak with my lawyer. And that card is designed for an individual stopped by ICE to hand to the ICE officer to inform the ICE officer of the interest in asserting the constitutional rights that each individual has. And theoretically, I believe you have those rights. Everybody has those rights. It's appropriate to assert them. I'm just not convinced that handing a red card to an ICE officer is going to end in a positive result. As I tell people, they have guns, and be careful. Okay, I think the next slide is open for questions.
So,
Oh, okay.
this has been really, really informative. And go ahead and cover these actions. And I'm going to ask everyone to please stay as long as you can, because I think we can have a really good discussion here. But we'll probably go another 20 minutes if people are willing with questions. So go right ahead, Robert, with your next slide.
Okay. What can we do? I struggle with this every single day. Be informed. The fact that you're here is a test to your interest in doing that. There's a lot of bad information out there. So when you see information, be critical on the resources that you use. The sites that I gave you are sites that I believe can be trusted. Not every site can. So make sure that your information is accurate. Voice concerns. I believe that I think it's important to tell our representatives what we're thinking, where we object to policies. I think that's important. Um, I I have to couple that with the fact that I have spent the last 25 years making annual trips to Capitol Hill to tell members of Congress what I think should be done in the world of immigration. I'd like to tell you that they've followed my advice. Not once. Not once has that actually happened. It's frustrating. And at the same time, I go back every year. So keep it up. Uh, at, it's important that members of Congress understand the difficulty, the problems that these policies create for real people. Social media. I'm not a big social media person. I think that's probably a function of my generation. I don't know. But those of you who are active on social media, it's a very effective tool at communicating views. Donations are important. I just came from a CRIS board meeting, and one of the things that we're terribly concerned that our funding is being cut. So organizations like CRIS, like the American Immigration Council, National Immigrant Justice Center, all are in need of funds.
Right.
It's hard to give money to everybody, but donations are important. Most important, vote. Okay. So one question here is, what are the voting rights of residents? Very, very limited. Non-citizens are not entitled to vote. There are limited cities across the country. I want to say only in California, but I'm not 100% sure about that, who provide residents the right to vote in city elections. Non-citizens are not eligible to vote in federal elections. And in fact, voting, representing yourself as a citizen and voting when you are not a citizen is not only is it a crime, but it is an unforgivable sin in the world of immigration and subjects you to deportation.
I want to ask a question.
Sure.
Voicing our concerns is very important in voting and staying informed. So I have a devil's advocate kind of question. This appears to me that everything that you're just describing about all these deportation policies seem to me that they're nothing but pure discrimination and the desire to create chaos. But I want to ask the question, are there any legitimate underlying benefits to any of these deportation policies? Because obviously some people think that there are benefits,
So,
and be informed and to be able to combat that, it's helpful to know what they're thinking. So is there anything legitimate on the other side of this?
well, so yes, there is. I describe myself as an advocate for immigrants and immigration, but I am not suggesting that the border be flung open and anybody who wants to come permitted to come. We do need orderly immigration. There are limits. Criminal record checks are important. I mean, we don't need to bring criminals from around the world to the United States. People who commit serious crimes in the United States should face removal. And so I think that the laws, it's the hyper enforcement of the laws that I think is unacceptable. Somebody who's committed serious crimes should be subject to deportation. I don't have a problem with that. I have to give you the example. I talked about students. So student visas were revoked if they've had any law enforcement encounter. There was an example of a student in Minnesota who was stopped by the police for the horrible crime of changing lanes without a turn signal, something that none of us have ever done, except that I did that on the way here. She wasn't even given a ticket. She was just stopped, but somehow that showed up in a police blotter. And so her student visa was revoked. Now, that was reversed by a court. That kind of enforcement is, I think, unwarranted. On the other hand, El Chapo, when he's finished with his sentence, I think it's appropriate to deport him. I don't have any problem with that. So, yes, there are reasons that deportation is appropriate, but they have to be done with due process and they have to be done reasonably. I'll tell you one thing that is really troubling. There is a provision that any domestic violence infraction is deportable. And I don't want to defend domestic violence. Domestic violence is a horrible problem. But what that often does is a family who has some sort of turmoil, rather than addressing that, and sometimes some families, it's appropriate for counseling. Some families, separation is the only way. But a deportation without any ameliorative ability often will leave a family without a support. I mean, if you deport the only person who's providing financial support, that leaves the family in straits. So while that's well intentioned, it has some adverse consequences. On the other hand, there are people that have engaged in horrible crimes and deserve to be deported. But we need to be able to distinguish between those, and we generally do that with due process.
There's several other questions on chat.
Yeah,
if you scroll up, there's
Okay.
one from Srinivasan, one from Moorman.
While you're looking at that, why don't we go to Kitty's question next? Because it kind of is an overall kind of question too. And Robert, what do you tell Congress about what needs to be done when you're testifying there?
Well, so I've never testified, but what I do is lobby, and usually with a specific hit list. For example, last time I was there, we were arguing for provisions to expand waiver ability. This is going to get really deep in the weeds. If you are an exchange visitor that has come for graduate medical education, a residency program, you're subject to a 2-year home residence requirement. Before you can change your status to H1 or permanent residence, you have to go to your home country for 2 years. There's a waiver provision for that. If you are going to serve in an underserved area for at least 3 years. So it's called the Conrad program. Each state has allocated a certain number of Conrad visas for doctors who are going to serve in underserved areas. And we were there to argue that that program should be expanded, renewed and expanded, because it expires every 5 years for reasons that are not clear to me. But we were there to argue that it should be renewed and expanded. We received a favorable reception. It was in fact renewed, but it was not expanded. And it wasn't expanded. I'm going to we were in the office of one Southern senator. We'll leave his identity anonymous, from a state in which large numbers of women in the rural areas do not have access to obstetrical care. There are places in this state where if you're pregnant, it'll take you 2 hours to get to a hospital where you can deliver your child. And we were arguing for an expansion in that state of visas that would allow doctors to come in and work in underserved areas. And the response we got was, that's really good. I support it, but not until we seal the southern border, which isn't the same thing. In the meantime, women in this state need obstetrical care. That's important. But it was put on the back burner until the border was sealed. So, okay. Does that answer?
That was one really good
Okay.
example of
So,
lobby for. But what other changes would you like to see in the existing laws that govern?
okay. So one of the things, one of the questions that was asked in advance that I did not address is, how is the law? Why is the system so dysfunctional? And we have numerical limits on immigrants, permanent resident visas that were established in 1990. And there are per country limitations. This affects, in the employment world where I spent most of my career, it impacts India and China directly. I had a large number of Indian doctors who were working in hospitals in rural areas, and they had to wait. The process was 13 to 15 years to get a green card. That's dysfunctional. One family I remember in particular, we started working on it. Their children were in kindergarten. We were still working on their case when their daughter was trying to get into medical school many years later. That's dysfunction. That's a question of limitation. And the numbers of visas don't make sense. And so what we're looking for, what we often ask for, is comprehensive reform. One of the things that you've heard about for many years is the DREAM Act, which addresses the problem of children who were brought here without authorization when they were very young, and they have grown up here. There are, I think, something like 800,000 or 900,000 people with DACA, Deferred Action for Childhood Arrivals, a program instituted by President Obama that was considered temporary because Congress was going to consider finding a permanent solution for these children, who many of whom are now close to 40 years old. Congress just hasn't done that, despite widespread bipartisan support for the DREAM Act. But there's always been something that has made, well, we'll do that when something else happens. The goalpost keeps changing. Okay.
Let's go back. Let's go
Go ahead.
back to some of the other questions on the chat.
So
If you
Srinivasan has
scroll-
asked, are executive orders being used increasingly over the last 2+ decades, or have they been used quite a bit even before? So there have been executive actions over the years. What we are seeing currently is a lot of very extreme executive actions. But DACA, for example, was an executive action in 2012 that was published by President Obama. So there have been uh, the executive orders are a result of congressional inaction.
Yeah.
Congress has been MIA, and until they actually take the role seriously and address immigration as grown-ups, which they are unable to do, we're going to have a ping pong effect depending upon which administration is in power at any given time. That's sort of my take on it. Is it true that it's a misdemeanor offense to cross the southern U.S. border without going to a port of entry the first time? Yes, I believe it is. I believe that's a misdemeanor. It's very rarely enforced. It is not a crime to be present in the United States without authorization. Being an undocumented immigrant is not a crime. However, there are lots of ways in which an undocumented immigrant can commit a crime. One of the things that I have counseled for many years when I'm asked by somebody without documentation, filing a tax return is a requirement. If you earn money, even if you are working without authorization, you owe taxes. It's a crime not to pay taxes. I file a tax return, and I tell immigrants to file a tax return also. Okay. I don't know if that answered that question or if there's a follow-up. Is a refugee considered a permanent immigrant, humanitarian, or other designation? Can someone's citizenship be revoked if they lie on the citizenship application? Those are two different questions, so I'm going to take them separately. Refugee is granted the right to remain in the United States. A year after they are here, they are entitled to apply for permanent resident status. Excuse me. And once they become a lawful permanent resident, then they have all of the benefits of LPR status. They must be a permanent resident for 5 years before applying for citizenship. The year before they apply as a refugee, that 5-year period counts from the time they are admitted as a refugee. That also applies to asylum, which raises the question, what's the difference between asylum and refugee? Nobody asked that question, but I'll ask it and answer it. A refugee is processed abroad and comes in as a refugee. An asylee is somebody who is here in some other status or a lack of status and applies for asylum based upon a well-founded fear of persecution should they return to their home country. And it must be based upon one of 5 factors: national origin, race, religion, political opinion, or a particular social group. That's an asylee. Okay. Can someone's citizenship be revoked if they lied on their citizenship application? Yes. The answer to that question is yes. Not very common, but the government has created a denaturalization task force to look at naturalization cases to see if there should be more denaturalization cases brought based upon misrepresentations on the application. Historically, most of the denaturalization cases have been Nazis. And there is a question on the application for permanent residence as well as citizenship. Were you a member of the Nazi Party, and did you participate in the persecution of people based upon their religion during the period from 1933 to 1945? A number of people were naturalized who should have answered that question yes, and it was later discovered those people were subject to denaturalization. There was a recent Sixth Circuit case where a individual was arrested and arrested before his naturalization interview, convicted after the interview, but before he became a citizen, before the ceremony, if I remember the facts correctly. And he lied about that. When that was discovered, the Sixth Circuit upheld the denaturalization. That's within the last year or two. There's a question on the naturalization application. Have you ever been arrested, convicted, indicted, or cited for any offense? Cited includes traffic offenses. So when I represent somebody on a naturalization application, we'll include all their speeding tickets. I would suggest that a failure to identify speeding tickets on a naturalization application would not be upheld as a basis for denaturalization. The Sixth Circuit case, I think, was bank robbery or something like that. That's a different story. Okay. Let's see. Over the last several months, there have been many deportations without the opportunity for a hearing. Where do things stand regarding receiving a due process hearing before deportation? Well, the courts are pretty clear that you're entitled to a hearing. There is a provision in the immigration law called expedited removal, in which case you are not entitled to a hearing. This is generally, when Congress passed this, it was people who were apprehended at the border as they crossed without authorization, EWIs, as I indicated before. There's a current effort to expand that to anybody who was not inspected. The courts are looking at that issue. It's actively litigated in dozens of courts across the country as we speak. People who have been here for long periods of time, undocumented, 10, 15, 12, or 20 years, have families, are being picked up and put into expedited removal. That's being tested in the courts. We'll have to wait for a final answer on that question. Okay. The courts have been pretty sympathetic. Courts are generally sympathetic to a need for due process. Have I covered all the questions?
I think you have. I think you've covered everything in the chat and done an excellent job with it. I do want to give our audience a chance to ask any final questions or make any final comments. Robert gave us a really good list of things we could do, but are there any comments on that anyone would like to make on anything you think the league or you?
Okay.
Oops.
I think you froze. Okay.
I will watch out for her in case she comes back. Cheryl, are you still with us?
I can hear you.
Okay, great. Well, I can go ahead and ask my final question. You mentioned your role with Chris, and I just wanted to know if there's any other local Columbus, Central Ohio, based groups that we can support, initiatives happening, current pieces of legislation that we can support, or what kind of is the state of all of this in Columbus right now?
So there are other organizations in the resettlement, the refugee resettlement world. ETS, Ethiopian, I don't remember the full name. There's an Ethiopian resettlement agency. No, I'm sorry. JFS, Jewish Family Services, also engages in resettlement efforts. There is, I wish I had more information on this, but we were talking about this earlier today when I was at the Chris office. We haven't talked about the extraordinary amount of additional fees that have been imposed on applications for work authorization for refugees and asylees. That was in the One Big Beautiful Bill. Uh, it's onerous and has been a serious problem. There is an organization, I couldn't tell you what it is, but I know that I've seen it exists, where they are collecting fees to help people pay those exorbitant fees. I don't have the information off the top of my head. I know that that exists. I'm not aware of any local legislation at the moment.
Okay, any other comments before we close? Let's see, Sophia added a note that this video recording will be available. Robert, we can talk to you about what sections, if any, of your deck we can share with people. And we will at least get out your list of references to everybody as well. And on that note, I want to thank you, Robert, for a really excellent presentation. And thank you to everybody who attended tonight and your excellent questions. I feel like it was a really wonderful learning experience. And Jay, thank you for your work to bring Robert to us. So
it was a pleasure connecting with him after all these years. So that worked out well.
I appreciated the opportunity. Thank you.
Well, good. To learn more about the League of Women Voters, please go online and go to our website or send us an email. We'd love to have more people become active in the League of Women Voters. So on that note, I will wish everyone a good evening, and we'll all go away being much better informed than when we started the evening. So Robert, thank you so very much.
My
Thank
pleasure.
you.
Thank you.
Thank you.
Good night, all.
Good night.